you are in fact a tax resident or a tax non-resident of South Africa.
No, that's exactly what I'm saying, right? And SARS has an interpretation note which specifically speaks to their interpretation. When one fails the ordinarily resident test, you cannot arrive at the conclusion that you are a non-tax resident in South Africa.
Delano, thanks for joining us here today to chat a bit about South African tax residency and a bit about expatriate tax and the broader South African tax system, and what your experiences have been in recent times with what's happening in the market and general trends. I think if we can start with that.
No, thanks, Richan. Conversations like this, I think it's important, and one really needs to take note of a couple of trends that we've seen. And one of those trends is that there's quite a bit of high-skilled professionals that are considering relocating, whether it's permanently or temporarily from South Africa. And there's a real tax consideration that needs to be taken into account. This is really where we as a firm come in to give good tax planning and to assist these taxpayers on how best they can be tax compliant. And the starting point for me is always understanding the current regime, that South Africa's tax system is currently residence-based.
Now, Delano, what does it mean for the tax system to be residence-based? Can you unpack that a bit for us? How do you determine that, and what does it practically mean for South Africans?
Sure. So a residence-based system in a South African tax perspective means that if you are a tax resident in South Africa, SARS has a taxing right over your worldwide income and assets.
Interesting. Okay.
But what's also important to note, and it's a key question that often comes up, is, well, what does it mean to be a tax resident in South Africa? And what does it mean if I'm not a tax resident in South Africa?
That's a very good question. And how does one determine whether you are in fact a tax resident or a tax non-resident of South Africa?
So under our current Income Tax Act and framed on this residence-based system, we determine whether an individual is a resident for tax purposes based on legislation. And the key legislation we look at is the Income Tax Act. And that act has a very specific definition for the word resident. When you unpack that definition itself, what you find is typically two tests, which SARS recognizes in its interpretation notes. One is referred to as the Ordinarily resident test, and the second one is referred to as the physical presence test. The order of those two tests is crucial for proper determination of one's tax residency. And if you follow the actual definition of the word resident, you will see that the legislature addresses the ordinarily resident test per se as a first determining factor. If you are ordinarily resident, this is a heritage concept, by the way, that has been unpacked by our courts to give us guidance on its interpretation. And it really comes down to considering South Africa as your real or permanent home.
So what you're saying, in other words, is that the ordinarily resident test is not defined in the Income Tax Act specifically, but rather over time it has developed and grown.
No, that's exactly what I'm saying, right? So the Income Tax Act doesn't extend a definition which caters for the very term of ordinarily resident. And because of that, we have a legal system that takes into account judicial precedent. And when you look at that precedent, we have certain case law that gives us an indication as to how the courts interpreted that meaning.
Now, Delano, that's fascinating to see how it has developed. That tax law is in fact not a static item or area of law, but it's developing to meet current and contemporary trends in the broader society. But how then, under the ordinarily resident test, does one determine if a individual South African is in fact a resident under that test, from a high level in your experience and understanding of that test?
So I'd say from a high level, you can really break it down into two considerations. One being subjective and the other being objective.
Right.
The subjective consideration is really the intention of the taxpayer.
Okay.
And in order to balance out whether this subjective intention meets the threshold for what is regarded as an ordinarily resident, you consider objective factors.
Right. Okay.
And SARS has an interpretation note which specifically speaks to their interpretation of this test.
Okay.
And they actually set out 13 objective factors, which is by no means a closed list.
Okay.
But when you do that comparison, keep in mind that a very important legal principle in South Africa is the burden of proof.
Interesting.
And the burden of proof in tax law, we are speaking about a balance of probability. So if you really want to know if the subjective intention tips the scale in favor of you being ordinarily resident, one can say that I only need to win this argument up to 51%.
So that it tips the balance in favor of your argument, in other words.
I would say so. I mean, if one takes a different view of, well, why are there only 13 objective factors? Why is it not an even number? That could also be something that lends merit to that argument. But again, it is not a closed list.
So you, in your view, would you say that it perhaps was not necessarily the legislature's intention, but perhaps SARS themselves or the courts to leave it at an even or an uneven number such that it would inevitably be tipped in favor of one or the other being a resident or a non-resident?
Well, it's a fascinating question, and I certainly would want to look deeper into that. But what is also interesting is that South Africa's tax system, which is currently residence-based, has been around since 2001.
Okay.
And since 2001, SARS has only released 2 issues of its guide and interpretation note of the ordinarily resident test.
Right.
So I think a good starting point would be to look at issue 1, which might be in SARS's archives, and to see whether it has any subtle changes to it in comparison to the current issue.
Right.
And whether there has been a consistency of 13 objective factors, albeit not a closed list. That might give us a clue as to what SARS's intention was behind that interpretation.
Well put, well put. Right, no, thank you for that explanation, Delano. I think crisp, but still high level. And You mentioned a second test in the Income Tax Act to determine a natural person or an individual's tax residency status in South Africa. Would you mind telling us a bit more about that and the interplay between that and the first test, the ordinarily resident test? Yeah.
So, to be fair, I find this as a more fascinating test.
Okay.
It's a test that finds its application for years of assessments where the individual taxpayer is not ordinarily resident.
All right.
So what I mean by that is when one fails the ordinarily resident test, you cannot arrive at the conclusion that you are a non-tax resident in South Africa without considering the physical presence test as well.
Right.
And this means having a proper consideration of a taxpayer's tax residency status.
Okay.
And this physical presence test has 3 requirements, to put it simply. The first requirement is to look at a current or relevant year of assessment.
Okay.
And determine whether you have physically been in South Africa for a period or periods exceeding 91 days in aggregate.
All right. Okay.
If you meet that test and the first requirement, you can then move on to the second requirement.
Right.
And the second requirement is that you are also physically present in South Africa for a period or periods exceeding 91 days in aggregate for 5 preceding years to the relevant or current year of assessment.
All right. Right. So it runs over a period of 6 consecutive years of assessment in South Africa.
That's correct.
Now, what is a year of assessment compared to a calendar year in South Africa specifically?
Well, it's a very good question. And maybe just to close the loop on that test, the third requirement is that if you have satisfied, in excess of 91 days over the 6-year period, the 5 preceding years of assessment, one needs to achieve a total of more than 915 days overall. When you meet that,
Right.
you then go back to the first requirement, which was the current or relevant year of assessment,
Right.
and one becomes a tax resident in South Africa for that year of assessment, which begins on the 1st of March. So a year of assessment, then, to answer your previous question, is the tax period in South Africa, which runs from 1 March during a calendar year
Right.
and ends on the last day of February of the following calendar year.
Right.
So either the 28th or the 29th of February.
And that's now your year of assessment.
And that is your year of assessment for South African tax purposes.
Okay.
And in comparison to a calendar year, it simply means that the commencement and end dates differ in that a calendar year commences on 1 January and ends in the same year on the last day in December.
Right. Okay. No, thanks for clarifying that, Delano. Then, in summary, we've discussed South Africa's tax system and the importance of determining tax residency for individual taxpayers within that framework and that system. The next question that comes to mind is, for the average South African living and working and being resident in South Africa, one would presume that they are resident in South Africa such that they are taxed on their worldwide income and assets. the question then arises from that, well, what happens where a South African individual departs from South Africa, relocating abroad to pursue alternative opportunities? And we know from media reports that there are tens of thousands of South Africans that depart from South Africa every year to seek alternative employment opportunities, perhaps more politically stable environments, and for a host of socioeconomic reasons, depart from South Africa and work abroad. In the context of tax and the South African tax system, what happens to them likely when they depart and work abroad? What is the effect of that, in other words, from a tax perspective?
So perhaps on a lighter side, I think the effect of that is when I am abroad, why is SARS still able to tax my income that I earn abroad?
Yeah, that's the question.
You know, and the sentiment really is that these individuals who are leaving South Africa are typically looking for a financial break, financial relief. And if they are tax resident in South Africa, well, what becomes critical is to ensure that how do they change that status on SARS's system to a non-resident, which is not necessarily the only way in which they can protect foreign-sourced income. But the general thought is, if I'm abroad and the jurisdiction I reside in, whether permanently or temporarily, has a revenue authority which imposes their own tax, how is it possible that I'm still being taxed by SARS? Well, it's possible because of two definitions.
Right.
The first definition being the gross income definition, read together with the definition of a resident, which in simple terms means that you remain subject to tax on worldwide income. And if you say, well, how then do you become a non-resident in South Africa for tax purposes? This, interesting enough, brings me to a third test in the same definition, which classifies these individuals as a tax resident in South Africa per SARS's system. And the reason for that is, after you've looked at the physical presence test, there is a proviso that has been built into the definition.
Right.
And this proviso can be referred to as a so-called override test.
Interesting.
And this override test speaks specifically to becoming a non-resident in South Africa due to the application of a double taxation agreement. Right. Now, what does that mean? Well, what I mean by that is South Africa has entered into international treaties with a host country. Okay. And there's a variety of them. If one follows SARS's website on this particular topic, you will find that SARS actually classifies double taxation agreements and protocols. Protocols meaning these are documents which have come into effect to enforce an amendment to an existing double taxation agreement.
Okay.
And these are separated in the classification of those which South Africa has entered into across Africa.
Right.
And the second being the rest of the world.
Okay.
And this is also important to note because not only does our domestic law recognize a double taxation agreement to make these individuals non-resident so that SARS cannot tax foreign-sourced income. In other words, protecting their foreign-sourced income and eliminating double taxation.
Right.
SARS recognizes this in the form of a so-called declaration. And this is interesting because we're now in a regime where SARS, in my opinion, is formalizing the tax base specifically in classifying taxpayers as resident on their system or as non-resident. And you don't become a non-resident simply by virtue of the fact that there is this double taxation agreement.
So if I understand correctly, you're saying that it doesn't automatically apply. It doesn't render a individual that has now relocated abroad automatically as being a non-resident.
I would agree with that. For two reasons which I view as consistent aspects of consideration. The first is that when you look at that definition of a resident in the Income Tax Act, the proviso specifically uses the word application when it relates to a double taxation agreement. On SARS's website of ceasing to be a resident, and the word ceasing, in simple terms is really the day you become a non-resident, the day that status changes from resident to a non-resident. SARS mentions 3 types of declarations. And one of the 3 speaks to an individual taxpayer becoming a non-resident due to the application of a double taxation agreement.
Right.
Not the existence of a double taxation agreement, not the enforcement. So the wording application is consistent with domestic law.
Right.
And that must therefore be applied to the fact pattern of an individual. So getting on a plane and leaving South Africa, unfortunately, is not sufficient to notify SARS that you intend to change your status from a resident who is taxed on worldwide income and assets to a non-resident who is only taxed on income sourced within the borders of South Africa.
Right. Okay, no, that's very well put. Before we circle back to the declaration that you described and some finer details about that, I believe with many South African expats, the sentiment is just that, as you've mentioned, we climb on a plane with my family and my belongings, and I have now departed from South Africa, and the income that I earn abroad is none of SARS' business. And the sentiment is that how will SARS know that I am in fact abroad and earning income, and how will SARS know and try to tax me on that income? Have you encountered any instances or cases where SARS may actually find out about that?
Certainly I have. And the conversation I usually have with clients on a day-to-day basis is deciding whether to have a head-in-the-sand approach or to follow an approach where you say, I prefer to do the right thing and then to move on. And what I mean by doing the right thing is appreciating that SARS has introduced the so-called golden letter of confirming your non-residency status. The correct terminology is a notice of non-resident tax status.
Right.
If you are not in possession of this golden letter, it would mean that there is a very good possibility that you are still a resident on SARS's system.
Right.
And if you have not obtained this letter, it becomes very difficult to accept that you are doing the right thing.
Right. That's well put. Then in light of that, with this notice of non-resident tax status confirmation letter from SARS being the end goal for a taxpayer to reach ultimate compliance and one can argue freedom from double taxation. How does one obtain that letter? What is the route or the routes or the paths to actually achieving that and obtaining said letter?
So, to obtain this letter, I think two formal procedures we can refer to as a financial immigration process,
Right.
being one, and the other being a double taxation agreement process.
Okay.
If I focus on those two specifically, what is very interesting to note is SARS issues the same confirmation letter, which confirms that you are a non-resident in South Africa. And that is interesting because under a financial immigration process, your intention is to be a non-resident in South Africa permanently. Whereas if you do it under a double taxation agreement process, your intention is still to return to South Africa.
Right.
Because you still regard South Africa to be your real home. And then the question is, well, if by their very nature they are actually different, what is that difference from a practical perspective in order for one to obtain this letter? And the first practical difference brings me back to the type of declaration one would sign. So if you go through the financial immigration process, the declaration you sign as one of the relevant supporting documents SARS would like to consider would specifically mention that you cease to be a resident in South Africa because you cease to be ordinarily resident. You no longer regard South Africa as your real home from a subjective perspective, tested against objective factors, typically taking practical steps to wind down your personal and economic affairs and relations in South Africa and to relocate that abroad. On the other hand, the declaration you will sign under the double taxation agreement process will say that you are a non-resident due to the application of a double taxation agreement. And that, as a relevant supporting document to focus on the DTA, needs to be accompanied by 3 additional documents.
Right.
One, which is very critical, is you would need to furnish SARS with copies of your passport stamps and all pages to indicate the relevant exit date from South Africa and date of entry into the host country.
Right.
In some jurisdictions, there is no passport stamp to be obtained, and this might be an electronic version or a reporting system which can accurately reflect your travels in and out of that country.
And SARS would accept that.
Correct.
Okay.
The next document is a letter of motivation, setting out your facts and circumstances in detail in order to support the disclosure to SARS that you have changed your status from a resident to a non-resident. A side comment there is to appreciate that every resident who becomes a non-resident in South Africa does have an impact on the South African fiscus.
Right.
And SARS's ability to collect more revenue. So in detail, for me, is indicative of the level of scrutiny required to determine if one legally qualifies for this relief. The third document, right, is a certificate of tax residency from the host country's revenue authority. Alternatively, a letter confirming your residence by that host country's revenue authority, that you are a tax resident there.
Right.
These 4 documents together is what SARS will typically consider before issuing a taxpayer with a notice of non-resident tax status confirmation letter under the double taxation agreement process.
Right. All right. And you mentioned previously that there are several types. Are there any additional types of declarations or ways in which a taxpayer can seize residency apart from the financial immigration and double tax agreement processes?
There's a third declaration which SARS recognizes, and that's when you become a non-resident in South Africa due to your physical presence. And to put that in a very simple context is to rather think of an individual who had a permanent home outside of South Africa.
Right.
And they enter into South Africa on the basis that they are not ordinarily resident. Their home is still somewhere else. But by virtue of their physical presence in South Africa over a period of 6 years of assessments, they trigger tax residency in South Africa. And when they trigger it and become resident for the relevant or current year of assessment, it's important to appreciate that that same test must be applied on an annual basis.
Right.
Which means that should they extend their stay in South Africa for another year of assessment, but fail to meet the first requirement of being in South Africa for a period or periods exceeding 91 days in aggregate, they would not satisfy one requirement out of 3 for the physical presence test whilst not being ordinarily resident. And thus, being a resident for the previous year of assessment would then mean that for the following one, they now cease to be a resident in South Africa due to physical presence.
Very interesting. All right. Now, Delano, to move a little bit forward back to the notice of non-resident tax status confirmation letter. I'm sure many taxpayers that embark on this process and do actually obtain this letter would raise the question that, does this letter expire? Is it a process that they must undertake or embark on a recurring annual basis? Is it a once-off process with SARS or engagement with SARS, or is it something that needs to be repeated every year for the duration of their stay abroad?
Well, I think if it was a letter you need to obtain on an annual basis, they wouldn't refer to it as the golden letter.
Right.
So I think what's written on that letter is really worth its weight in gold. But I do appreciate that that letter indicates an issuing date as to when SARS has issued the letter to the taxpayer. It also reflects an effective date as to when that taxpayer became a non-resident on SARS's system. But there is no expiry date on that letter. Now, that's not to say the letter that SARS gives you confirming your non-residency is valid in perpetuity. One must appreciate that that very same letter has a built-in obligation which rests on the taxpayer to notify SARS of a change in their status or registered particulars within 21 business days of such change. And what I mean by recognizing that as important is that under a DTA, because those taxpayers who might have gone abroad for employment opportunities, maybe a secondment, maybe they are testing whether the grass is greener on the other side, and they've not precluded the possibility of returning to South Africa, when they do come back with that intention to re-establish South Africa as their real or permanent home, when they land in South Africa, the clock starts to tick.
Right.
And they have 21 business days to notify SARS that they have now returned and they should be recognized no longer as a non-resident in South Africa for tax purposes, but rather a resident in South Africa for tax purposes. And on a closing point, you could then say, well, maybe that could be interpreted as a circumstantial expiration date.
Right.
So an expiry of being non-resident dependent on the taxpayer's circumstances.
Right. No, very interesting, Delano. And thank you for providing this level of clarity and detail. And I'm sure many South African expatriates abroad will find this informative and helpful. And tell me, how can you be contacted or reached for those expatriates who seek additional information or further clarity or assistance?
Well, I think all taxpayers and those expats in particular are welcome to visit our company website, Tax Consulting South Africa. We also have a web page for double taxation agreements. And I can be contacted on my email address, Delano, that's DELANO, @taxconsulting.co.za.
Thank you, Delano.
Thank you, Richan.